Hi friends, welcome to the channel. This is your Govindraj. Thank you very much for watching my previous videos and also sharing it in your network. As also spoke about in the previous video, today this channel has got more than 245 technical videos and highly technical and also backed by the case laws and judicial trend. There are more than 55 technical videos are available in membership channel. Of course, the free channel is available for everyone, but the membership channel, you have to become the member of the channel so that you can continuously watch the technical videos and clarified very precisely, and that is going to come only if you become a member. So I'm going to give you the channel, the membership link in the description box. You can click that link and become the member to watch continuously and endlessly all the technical videos which are explained very clearly. So what we are going to talk about today is we are going to talk about the standing orders. The standing orders are nothing but the terms of employment which are statutorily recognized and certified by the authorities in the authorities of the government. We are going to also talk about when it is mandated, what the employer responsibilities, all those things. But the objective of this video is also to tell you that when you are getting certified your standing orders or when you are getting modified your standing orders, normally people who do these jobs make a lot of mistakes and they only refer one or two standing orders and they cut, copy and paste. They will not know what are the repercussions of missing there are certain key terms. Now only people who are experts and continuously reading, they will only know which is the judicial trend, what are the key terms which are to be brought in the standing orders. I'm going to demonstrate to you certain key terms where normally they gets missed in your standing orders because of lack of expertise and lack of reading. And if you only copy and paste this, you are going to definitely do such a mistake. So we are going to talk about this topic today and understand the requirement of the law and the key terms which you will not know normally unless you go to an expert and continuously reading. So let's proceed, friends. So before I'm going to the key terms which you may miss because of lack of expertise and continuous reading, let me tell you what is this statute is all about. See, this Industrial Employment Standing Orders Act 1946 actually provides for an employer who has got 100 or more workmen, then this statute applies and that employer is actually required to get his standing order certified for his worker. And many states have made this statute applicable to also when these establishments have 50 or more workmen, and today many of the states have reduced this threshold. And as per section 3 of the statute, the law demands that submission of draft standing orders within 6 months from the date of application is mandatory in the hands of employer. And some states have enforced the model standing order alone. See, when the act is applicable, if you don't have your standing order certified, then in the act and the rules, as the states frame the rules, and as per the rules there are certain model standing orders which are stipulated by the government. If you do not have your standing orders, then the model standing orders are going to be applicable. But some states, like for example Maharashtra and Gujarat, if you look at their standing orders, draft standing orders are made compulsory, but however the employer has a possibility to suggest certain modification to the draft standing orders and get it certified for his establishments. So therefore this possibility is also there, and all other states, though they have model standing orders, the employer has an authority and power to modify the standing orders and get it certified for his own established based on the requirement of his business. So this is the gist of the law, where you have to comply the Industrial Employment Standing Orders Act 1946. And whenever any change occurs, and also whenever changes occurs in the employer or the establishment, or you want to get it modified in view of the changing needs of the society, you can also get it modified as per your needs. Also, let me tell you, even a single employee can also file for an amendment of standing orders as per the statute terms. So this is the gist of the law, friends. Now let me give you essential terms which you may miss if you only copy paste, and I've already told you, if you do not go to the expert and who continuously reads and practices about the standing orders and the labor law, he will know there are a lot of judicial trend where if your standing orders do not have these terms, then you will not be able to take the advantage of such terms. So therefore this is very important. Let me demonstrate this by giving you certain key terms where you may have the possibility of missing in your certified standing orders. Now the first one is this types of employment. If you copy, normally there are normal employment types like your permanent employees and badli and temporary, casual, all those things will come. But there are two things which are very important. One is fixed term employment and trainees and training scheme. Suppose if you do not have a provision in your standing order, you may get into difficulty of engaging these kind of people in your establishment. First of all, fixed term employment. So far in the earlier days, this fixed term employment was not available in the model standing orders. But nowadays, many of the state governments have brought amendment to their standing orders, and so therefore you will also be able to include this fixed term employment in your standing orders when you are certifying it or you are getting it modified. This is possible for you to include. The second one is trainees and training scheme. See, as an employer, if you frame a training scheme and you will be able to engage trainees on the roles of the company, and then there's a lot of judicial trend is there. Whatever today I'm going to talk about these key terms, definitely there are judicial terms, and every point what I'm making is I have the judicial trend with me. So therefore, when you have a trainees defined in your standing orders and you have a training scheme, you will be able to employ trainees on the roles of the company, and it is not mandatory on your part to make them permanent. So but if you don't have it in your standing orders, then you will have a difficulty and complications in engaging these two kinds of employments. Now let's look into matters related to sexual harassment. So many standing orders I have seen, they have failed to define what is sexual harassment and the objects and the matters related to this sexual harassment. There are two things which I'm going to tell you is under section 18 of the Sexual Harassment Prevention, Prohibition and Redressal Act 2013, under section 18 there is an appeal possibility. Suppose if your service rules or the standing orders have an appeal, internal appeal, then the aggrieved party is not required to go to the appeal authority nominated or prescribed under the rules of the statute. So therefore you have a possibility for internal approval, and then the complication there only gets nullified. Otherwise, if there is an appeal outside authority, then the employer and the aggrieved party are going to get into a lot of difficulties. So this is one possibility, and this is only possible when you have this appeal authority either in your service rules or standing orders. Now let's look at finality of internal committee report on sexual harassment. Today the legal situation is the internal committee report is not the final. So internal committee actually gives you a report and recommendation. Based on that, the disciplinary authority is required to take action based on the service rules and standing orders. In that process, he is required to do an additional inquiry as a full-fledged domestic inquiry if he is a workman category. But suppose you have included in your standing orders that the IC committee report will be treated as final, and then based on that the disciplinary action can be taken, then for you it is possible to go based on the internal committee report without getting into second inquiry, provided the internal committee has followed the principles of natural justice. This possibility is also there. Now let's look into some more terms where very difficult, you may miss it. One is retirement age. Of course, today retirement age, most of the states have amended to 60 years, but for you there is a possibility to include that after 55 or 58 years you will be able to enforce the fitness or the medical fitness. Based on that, you will be able to get your standing order certified. And possibility for flexibility in working hours, shift working, weekly holiday. If you don't have this, then while doing your normal work, you may get into lot of difficulty. Now let's look at right to layoff and possibility to retrench if the layoff continues for more than 45 days. Now you know that the Industrial Dispute Act contains provisions related to the layoff. It defines layoff, and there is a compensation related to layoff provisions under section 25C, under chapter 5A and 5B both. But what I am telling you is a right to terminate the services flows from the general law, but common law does not know the layoff. When you employ somebody, the employer has got inherent right to terminate the services. But if he does not have a right to lay off, if your service conditions don't have a right to lay off, then you will not be able to lay off your workmen. So therefore, if your standing orders do not have a provision for laying off, then you will not be enforced. You will not be able to enforce these provisions for your establishment fund for your workers. So I have given you some of the case laws which is by the apex court in the case of workmen of measures Firestone Tire and Rubber Company of India Private Limited versus Firestone workers case, which is in the year 1976. You can refer, you will exactly come to know about it. And also prior notice in case of strike. See, as far as the Industrial Dispute Act is concerned, notice is not mandatory before striking, except in the case of public utility services. The strike by the workman or the strike notice by the workman is not mandatory. Suppose you have these terms in your standing orders or the settlement agreed with the union, then you will be able to enforce this timeline the employer gets. Now coming back to acts of misconduct in line with the changing needs of the business and society. So if you have defined your standing orders with the limited acts of misconduct, I am afraid that any new misconduct which is not defined, you will not be able to normally take the action on such misconduct. And if you look at today, the society is changing, the technology is changing. Today the digital and internet is the prime factor, and the misconducts which are related to technology, digital, Facebook, WhatsApp, all those things, even communication of notice, if you do not properly word it in your standing orders, then you will have a difficulty when such situation occur for you. And also common proceedings in case of alleged same misconduct on more than one workman. If a single misconduct is done by a couple of people, couple of workers, or more than one worker, then you will be able to conduct a single inquiry for everyone, provided you have a common proceedings in your standing orders. Without that, you will have to conduct individual inquiries for your workmen. And also let's look at continuation of disciplinary proceedings on retirement. Normally the judiciary says you will not be able to initiate a disciplinary action once the retirement occurs, but provided you have in your provision the standing orders that though the retirement occurring, the disciplinary inquiry can continue beyond retirement, and you will be able to enforce the punishment, then it is possible for you to implement in your establishment. And flexibility related to data privacy of employees, this is very important term I am going to tell you. Today the law is changing. You already have a data protection laws in India, and then you as a information nodal agency, you are going to process a lot of employee related data, including their photographs, their database, their contact details, their family details, and you take a lot of videos and photos. You will use it in your social media handle, and then you will use it in your Facebook, you will use it in your brochure, all those things you will do it. But suppose if you don't have these rights to use their photographs and data for the business reasons, then the employee may sue the employer for breaching the data protection or the privacy details of the workman. So these are the some of the terms which I have told you, friend. There are many such terms which have to be carefully thought and brought into your standing orders. And whenever you make your standing orders or modify your standing orders, at least 10 to 15 years you should not be able to get into any issues, and it should take care of this timelines. Like that, you have to draft your standing orders. I'm stopping my video at this moment. I am sure I have made an object, and I have made your thought process sharp on this matter. Thank you very much for watching this video, and in case you would like to contact me or you need any assistance on this matter, I have given my coordinates in this video. Thank you very much friends, and see you soon in the next video, friends.